guys, and welcome to the early crew. So the stream I'm watching on my other screen, it hasn't started yet, and it says it's going to start at 9:30. So what can I tell you? But this might get boring fast, although I do have at least a clip from yesterday. Now, I heard, and I went back and looked at it this morning before I set this up, that the judge asked them to be back at 9 o'clock. So I don't know if she's got the jury coming in at 9:30 or the stream's going to miss something or whatever. But when it comes on, I will pop it up on the screen. I did make a little clip yesterday from Megan talking to the police out in the parking lot. And that question was asked, well, how can they do that? You know, because she's kind of confessing to some of the things she did, but they didn't read her rights. Well, at that point, the situation should have been a non-custodial interview with her. So they're just talking to her in the parking lot. She can leave whenever she wants. Once they take her into custody and they want to use something that she says against her, they need to be reading her rights first and get that waiver. But just standing out in the parking lot shouldn't be a problem. And you did hear the defense attorney say, well, was she free to leave at that point? And that's the kind of thing that you know, if you're not free to leave, right, they should be reading you your rights. But I think that argument should have occurred before the case started in a motion in limine or an objection when the evidence was introduced. And I don't know if I know it didn't get objected to, or I didn't hear that. I don't know about the motion in limine. And so I don't know if he was going to try and push that issue for appeal, but I think he just asked that one question. So if he really wants to make it an issue, you know, he would need to call her and say, oh, well, I was drunk. They didn't ask me. I thought I was being detained at that time, and maybe have that stuff thrown out. But I think it's too late for that. And what she did do in it was essentially admit that she threw this stuff on her father. So I just don't think there's any question about that. The father tried to, either because he was incoherent, wrong, or whatever. At first, he didn't say she did it. It might have been a bug bomb, or he didn't know. But then he told people she did do it. That's why they called the police. And then she told her, I think a friend or two, that she threw stuff on him. And then she told the police that as well, first saying, well, I only threw bread. And then I threw bread and water. And okay, I threw bread, water. And it's cleaning stuff. And when I'm going to show this clip in a second, I tried to enhance the audio, which I can't do as good as they can in movies, apparently, because the potato level audio and video they have of her interview is just terrible, because you'll hear her say, yeah, you know, I threw this white stuff on him. And the guy goes, did you know what it was? And she says something, and I just really can't understand it. I mean, I know what I think she says, but I couldn't swear to it. But I'm going to let you hear it, and then you guys can comment on it and let me know what you think. Again, I don't know if they're going to wait on the mainstream to just start it at 9:30, because that's what they have it planned for, or if they're going to get going earlier, if the court does. But I listened to the judge again this morning say it'll be back at 9, and that could be for pretrial things that they're not going to show or whatever. We'll see. All right, this is going to be a clip out of Megan's testimony, or her interview with the police, that was provided by testimony from the police. Here we go.
Was there any white substance that flew out of something when you threw something at them, or anything? We're trying to help your dad out here.
I think so, yeah.
Okay. It's like on the couch. Did you see like where it went on his body? Okay, well let me start here before you say that. Was he wearing a shirt? Remember? Shirt or pants? No?
I know he was wearing pants, but no.
Okay. So where on his body did you see that white stuff?
It mostly went on the couch, a little like on his like lower legs, but it was mostly covered with a blanket.
With a blanket? Okay. You know what that stuff was?
It was like something for the tub or something.
Okay. Alright. Now, do you ever use that stuff to clean the tub? So like during the like live.
Like when my it's not one of them. It's when my dad used to sometimes during the
I know that right here from all of them. Alright, so you know what that stuff does? It's something like scary. You don't know? What do you think it is?
So that's the clip. You know, they talked to her about other things, but they asked her, do you know what it was? And she had a discussion with them about that. I think later in the clip, she said, well, I thought it wouldn't do anything if it was just the crystals. But, you know, I take it to mean there that she didn't deny that she knew it was some kind of substance, potentially of the cleaning variety. But I couldn't swear to that in court. I can't hear it. I've seen footage and audio of Bigfoot meeting with aliens from outer space that is clearer and better quality than what the police have there. Like, why even have it on there? That was pretty bad. So I don't know. I guess it was the dash camera only. I don't know why the audio is so terrible there. You're talking to somebody that is material here, but it is what it is. So that's the clip that we've got. I don't know if anybody heard that better than I did. My hearing's not so good anymore, but I did hear her say that she threw that the white stuff came out when she threw it and went on his legs and on the couch and stuff. So, I mean, hello, you threw this lie on him, and that is the crime. As long as it was done with intent of an unlawful purpose, which, as we talked about yesterday, could be to injure, which she may not have intended, but it can also be to harass. And if you're throwing cleaning solution or something out of a bottle with a big skull and crossbones on it, if you don't mean to hurt them, then I think it can fairly be said that you did at least mean to harass them or something bad. And that just seems clear to me. So I think she meets the statutory definition. The interesting thing about this statute is it's not a murder statute, but death by result of this conduct can result in up to a life sentence. And I think the big discussion for this case is, well, how much punishment should she get? The bad things about her, to me, are she knew her father was burned and was taken to the hospital. She went to this party anyway. And when the police get there, do you hear any reaction from her about when they say, you know, your father's in bad shape and stuff? She's not like, oh my God, how bad is he? Oh my God, can I get to the hospital? She's like, oh, well, yeah, but I just threw bread at him. And she knew that wasn't true. She knew the burns were occurring because of something that had gone on with her. And so that's pretty stone cold. She's trying to lie to the police and stay at her party rather than worrying about what happened to her father. And even if it wasn't intentional, which, you know, she says it wasn't, the fact that it might have been an accident, does that mean you don't get upset about it? I mean, maybe you should be even more upset about it. Like, oh my God, I can't believe that happened. What the hell was this stuff? I didn't mean for that to happen. I threw something at him, and when I left, he was fine. What do you mean? What's going on? How could this happen? Instead, she's busy trying to evade and say, well, it was just a loaf of bread or something like that. So there was a discussion in there about the substance and whether she knew what it was and what it did, but I can't understand it. But I don't think I have to either to know what's up. And so I posted a few of these, and good morning to everybody who's on the early crew. Why am I doing this to myself and to you at this time of morning? Because I heard the judge say that she wanted people back at 9 o'clock, and I thought, well, maybe they will get started early, and I didn't want to miss any witnesses. And it's possible the other stream could crank up early when they do. But right now it's showing 19 minutes to go time for them. So that's the story. So we talked about how they could talk to her out in the parking lot without reading her Miranda rights. We talked about a potato level camera confession there. And I still have the Kayla testimony I could show again if anybody wants to see that. And maybe it wasn't the quality end. So not just an end, but the quality end. So that probably was pretty awesome. I did hear the mother yesterday clarify that she knew that the father had been burned and that Megan was having trouble with the credit card. And I'm like, okay, those two things don't necessarily need to go one after the other, do they? And that she did clarify, for the court that her father ultimately paid for the party. And so I'm thinking, why does she think that makes a difference in any way positive to anything? And I think toward the end of the day, you could see a terrible family dynamic there. So when this thing gets over to the punishment side of it, which is to me where this, anything can happen, right? Casey Anthony got off, so who knows? But she's probably guilty here. And if she is, then it's a question of how much punishment is the right amount of punishment for her. Because on the one side, it wasn't just immature rage act in the moment that she didn't know how bad this was going to be, threw it on him, and this is the worst thing that's ever happened. This was, I threw it on him, I got out of there and went to the party, still tried to get his credit card while he was being burned up, and even after he was in the hospital, and then lied to the police about it and showed no emotion to the police about my father being in the hospital burned up for something that I did. That's the bad side for her. I think the upside for her is, if you have any sympathy for her, it's like she probably grew up in a pretty bad situation, which many people do, right? Who had a perfect childhood. So that's not an excuse to obviously to kill somebody or even just to throw this caustic solution on somebody. But having said that, you listen to her mother and then the way the father was with credible testimony. that day when he was harmed by her probably didn't arrive completely out of the blue. So I think that, the judge is going to have some thinking to do. And so, I mean, normally the judge is going to do this, and I have not looked them up. I still haven't looked them up. I was doing some other stuff last night, but if this case is still going for tomorrow, I'll look it up tonight to see what they do, because a lot of times they'll have guidelines and things in place, presumptive for the judge based on, this, that, and the other. And if there's a pre-sentencing report and prior history, and the defendant can say something and the victims can say things, and then the judge has, whatever range of options the state wants to give her for that. And I can't see her getting a life sentence, obviously, for this, because that's the maximum. And while the testimony is bad, and I think she looks bad, I'm not seeing right now that she plotted to kill her father with this. And people who often plot to kill people don't get actual life sentences. So how's that going to happen to her? I don't know. And I don't have any sympathy for what she did. But if someone were going to have sympathy for her, I think it couldn't be because of her demeanor after she did it either, right? It could only be a belief that she got to be who she was in part because of an environment that she didn't have control over. But, she's 18 and you don't throw poison on stuff, on people. And wouldn't we have maybe a little bit more feelings for her situation if she put it on him and then he started reacting that it burned, and she's like, oh my God. And, and she called the ambulance and she stayed with him and she cried and this is so terrible. I can't believe she did it. You would think this was a horrible accident or a moment of rage rather than somebody who did this and remained cold and calculating after that. And all the comments I just said, even on the second end, I don't, think that she intended that much harm. I have seen credible comments that say that, that she perhaps did. But you look at the trial and you're like, well, have they proved that she wanted to kill him or whatever beyond a reasonable doubt? I don't see that. But I also can't imagine that they haven't shown beyond a reasonable doubt that she threw a chemical irritant on her father for an improper, the law says unlawful purpose. I think they have done that. And I don't think she's going to be able to excuse herself if I didn't know what it was or whatever. I don't buy that one, in my opinion. That seems to be in the water supply around America today, I think. There's a lot of that going on. And, I found her testimony a little weird in some respects, but it's also hard to get up and testify for the first time, which it seemed like it was for her. But, man, they kind of dunked on the father all the time there with the stuff about the mess with the family and stuff like that. The house being such a wreck and stuff. I mean, to me, if she's found guilty, isn't that more toward the family dynamic situation and whether she can be excused in some part for what she did because of the situation she was in? Isn't that more for sentencing than guilt or innocence? Like, this guy was a wreck apparently in his life, if you believe those family members. And it just seemed to me a little bit of a bashing on the victim there. They didn't really go too far with it. I mean, this trial's been really quick, right? It's almost over. But I don't like victim bashing, and it kind of just wavered over there a little bit, because I am sure that the people telling about all the bad things about him being drunk and how bad his house was aren't living perfect lives either, but there's no one there to go the other direction on it or stand up for this guy because he's dead. So this is all kind of interesting, because you heard also the guy talking in a video that the police had, the father who ended up dying. And I got this poll running that I want to get to at some point that has come up more because of the Brooks trial, which is, should people who are either claim to be, or you really think they are victims in a criminal case particularly, should they be able to do their testimony in some remote ways that are not around the defendant? That poll is running. I mean, the law is basically no. If you've got to come to court, and there has to be a face-to-face encounter. That's a constitutional right. That's the way it's interpreted, and to me, that's interpreted correctly. But I respect that other people have different opinions, and also other jurisdictions have different rules. So I'm kind of interested to see the thoughts on it. And since I didn't say criminal trial in the poll, there are some comments that apply to civil cases, which are really good comments. And I think that mistake is good because we can talk about that too when we get to it, which is, wait, I see my wife on here outing my 39th birthday. And I would not be able to prove that statement beyond a reasonable doubt. No one's going to buy that. But anyway, back to the poll. We'll talk about, civil case doesn't have the Sixth Amendment consideration in it, right? And then also, the worst example is you're entitled to confront your witness. If you kill the person and they've had something to say about you, you can't confront them. They're not available to say it in person because you murdered them. It seems like a benefit for the defendant then, right? Oh, well, Your Honor, he can't come testify against me because I killed him. So I'll kill any witness who wants to come testify against me, and then there'll be no trial. And anybody who ever wants to come against me, I will do the same thing. So I'm immune from suit. It doesn't really work like that, but the rules are ultra complicated. And they kind of came up in the Mark Jensen case because the state using the letter that the wife wrote, basically saying, if anything happens to me, go look at him. He's the one trying to kill me and stuff. And she wasn't there to say it in person because he murdered her. And they did use the letter, and it went to state court, and they said, it shouldn't have done that, but he would have been found guilty anyway. And then it went to federal court, and they said, no, this was a big constitutional violation because this was testimony by a witness against him, and he wasn't able to confront or cross-examine on it. So you got to do the trial again. So it gets really complicated. So I don't want to be wrong on or miss a major thing. So I don't know that I'll have that stream tomorrow on that, but I'll get to it soon. Because I'm a little derailed on a real life case, plus that I'm having to work on in the afternoon since we've been doing this case. Although this case did finish early yesterday, and that let me get some things done. It was awesome. Yeah, so everybody's like, "Oh, his house was a disaster," it's disgusting and stuff like that. Yet she and the brother chose to be there, and that's either because the mom's place was considered worse by them, or maybe the mom had rules the father didn't. Maybe it's the way the dynamic went during the breakup. I don't know those things, and since they're not relevant to whether she's guilty or not, in my opinion, I hate to go down that rabbit hole because, first of all, he's dead and he can't speak up for himself, and second of all, I think somebody gets to that condition, it's pretty sad. I think he didn't want his daughter in trouble. He was literally trying to give her credit card information while he was burning. So there was a love there, even though he was, by testimony, a very imperfect person. Let's see. Not sure. The question there, I might have missed the context because I was running my mouth and not catching all the comments. So if you let me know that, if I know the answer, I'll give it to you. Let's see. All right, we're in the single digits now until the official stream starts, and maybe it'll be in progress, or maybe I jumped the gun on this, and I'll wait a couple minutes and maybe play this Megan testimony again, because I haven't heard it, or if I did, I missed it. Anyone say whether they heard more of her statements and can make it out than I did. I heard her say, yeah, the white stuff came out, it went on his legs and on the sofa, and then another critical question was, hey, did you know what this is, what it does? And then it went into potato Bigfoot alien mode, and I couldn't make out what she was saying. Yeah, and this could be too. It certainly could be. I mean, I find letting yourself succumb to alcoholism and not fighting back against it is kind of a selfish thing to do, even if circumstances are hard on you. Having said that, life can be hard, and sometimes it just happens to people, or they have a predisposition toward it and stuff like that. But I've seen the consequences of it myself personally, and involving a lot of violence. So I have to say, it's your personal obligation to do something about it if you find yourself in that situation, even though I understand how people get there. All right. So thank you very much. I appreciate it. I'm in a higher number than I planned to be. Okay. Well, I don't think that's good necessarily that the mom would be on a stream talking about the case while it's going on, but it's, if she wants to do it, then I guess she'll just do it. She's testified already, and that's over. And I didn't think she said anything earth-shattering in the trial, so I don't know what she could say now that was too much of a difference. If it's to bash the guy more about how nasty he was, I wouldn't want to hear it, because there's nobody asking her about how great she is. And I don't know that she is great. I would assume not, without trying to slam dunk her. I have my own suspicions from listening to her on the stand about her life and her participation in the events. And I don't think this was a one-way street. Let's see. And, furthermore, if that's true that she goes on a stream during the middle of the trial and starts talking about the case, I mean, that's pretty lame, right? Isn't she was also the one that watched the stream before she testified. So doesn't that tell you something? If she's watching it on TV, and she knows she shouldn't do that, even if the lawyer didn't tell her, but he probably should have, but even if he didn't, you don't do that. And then you get on a stream right after you get off the stand. I don't think so. Yeah, and in terms of the mom covering for the daughter, I mean, that's her mom, so that's understandable. Yeah, now I think the throwing it on him was intentional, and that it was a nasty chemical and stuff like that. All right, so there is some activity going on the trial stream. Let's see if that's just they are switching over to the courthouse. So I'm going to make that magic happen if I can, and then we'll come back to it. Yeah, it was intentional. How much harm was intended, I guess, is a fair question. And I do think it's intentional. I mean, she may get up there and say, oh, the cap is already off. It was just leaning and I tipped it over. She even told the police that cats knock things over before she finally admitted to what she did to you. All right, I'm in share screen mode here. Let's make it big time. All right, so we're in the game for when they start. And maybe they haven't started yet, since they're just showing the seal. And the judge asked them to be back at 9, I think, but they may have had things to talk about. I don't know if they settled on jury instructions and stuff like that. There's a lot of things that normally have ample time for in the case when they go longer than that are being compressed here. So this was my, issues here, which I think, going back to this, that you're right. I mean, you imagine that's true, right? You think, well, the cap was sealed, but have they shown that? But I would go with the assumption you're making there that it was, and that she took it off and all that. And that goes right down to your next. Thank you for reading my mind, which probably is a big font and not a lot, so it's easy to do. Is she taking a stand? The only person alive who was there when she threw it on him, it's her. So if the defense were to think that mattered, to say like, oh, he left it out open, or he had it in with these other items and she threw all of them at once and didn't know that was there, to get away from because you have to show it was intentional release of a chemical irritant for an unlawful purpose. So if you want to try and defeat one of the elements of the crime, and you believe the state has met its burden, then you need to confront that. The only person available to do it is her, unless they've got somebody else from the scene that could say that. But who else would it be other than her? So normally you would not have the defendant take the stand, and probably she would not. Very probably she would not. But on the other hand, if she doesn't take the stand, she's found guilty, and she thinks, but I didn't do this or this, that, or, well, you got your chance right now. Okay, this is your case, and you can testify if you want to. And I know the major idea is don't testify if you're the defendant, right? But there are a lot of assumptions built into that, because generally it is a good idea to testify if you're a defendant, because you're usually it's a guilty person. It seems sometimes on social media that every single case that comes up, there are people like, oh, it's all made up. The evidence is a fraud. The state's investigation is terrible. And those things are sometimes true, but they are not, in my opinion, the majority of times. But even if it's rare, the defendant deserves the presumption of innocence, all the rights they have, a fair trial, and all those things, because the state has a lot of power to go up against people, a lot, and it is clearly sometimes abused. So I don't mean to say that just because I think they usually have the right person in the dock, means they always do, or that we should minimize any protections defendants have. Because I'm a big believer in checking the government power and putting them to the test because they want to take your liberty away. It didn't take long for starting in practice of law before I ran into a case against the federal law enforcement, not the officers per se, but the prosecuting attorneys abusing a civil forfeiture to when they seized a family's money, absolutely wrongfully. And when we developed the evidence to show that, they said, well, we'll give you half of it back because otherwise you got to litigate it. I mean, that's not how criminal law should work, right? These people should have their money back. So I lost a lot of innocence on that early case, especially at the federal level. Yeah, she did do that. So I don't have a sound yet down at the bottom. Let me check and make sure I'm not screwing that up.
My client and I have talked. I've talked to my witnesses. I want to make sure my client will waive her right to testify when she gets up, and we will not present any witnesses this morning.
Okay, so you're ready to proceed into closing arguments?
People are.
I can be, yes.
Okay, and then with regard to the final jury instructions?
Okay.
Are there any changes?
There would be one or two things that would have to come out, I think.
Yeah, I think there are a couple changes, but I don't know.
Wow. Alrighty. Looks like we're moving to closing arguments. Are you ready? Yes. Are you ready? I can be.
My final jury instructions have a 3.01, 3.2,
Yeah, this might be
3.3,
verdict glance too.
3.5,
If I were on a jury, I'd be like, yeah, she did it.
3.6,
The judge decides what to do with her, but she did it.
3.10, 4.01, 4.03,
So I've got to stop at 11:30, but I suppose we'll be well into this, probably off the stream before that even happens. The judge has got to charge the jury. I kind of want to hear that for the statutes and stuff. And if there's, I haven't looked at their jury instructions
Any facts, really.
No, we
to
really
see what
did.
they say.
So I take that out as well.
So here's a secret. If you want like the
There
most
was some
common
to
sense
admission of
explanation of
some
the law
exhibits.
quickly from another state, if
But
you
there
can find
wasn't
a pattern
actual
jury
fact.
instruction, that's what the judge tells the jury the law is in that state. That's a good starting point rather than, statutes can be a little bit
I think
confusing.
there was with regard to him
Even
being
picking the
intoxicated
elements out.
on
Case law
the-
can be confusing.
That's
So
fine.
jury instructions are
Want it
good
in or out?
primer for that.
It's not going to matter.
I don't think it matters, yeah. It's fine. We can leave it.
409, 416, 502, 503, 508,
I don't think there's anything for 508.
What if the judge has got her Miami South Beach glasses on again?
I don't think so either.
I think we could take 508 out, Judge.
510,
There was, but it would only just be Dr. Varani, so that would be the only person to list there.
That was the blingiest set of reading glasses I've ever seen.
N,
Virani.
first name.
Can you-
So those are jury instructions. They're usually numbered in the states, and so you want this one for say the burden of proof. This one for the elements of the crime. This one for any affirmative defense that's coming up. This one for how to weigh evidence. This one if you had an expert witness. So it'll be like 5.1, 7.2, stuff like that. Every state's different, but pattern jury instructions are a good place to find the law. In brief,
511, 723,
That, I think, would come out.
3903,
Of course, it stays.
72, 172A,
Yeah.
shout out to these lawyers who are
It's fine.
working well together to move things along rather than making everything as big a fight as you possibly could make it.
313,
Yeah. Good.
314,
Fine.
Good.
315,
Good.
That's fine.
316,
That's fine.
Good.
319,
That's right.
323,
That's right.
and the verdict form. Anything else?
I mean, they did this in what, 3 minutes?
Thank you.
Nice.
Just 3 pages out. Final verdict form.
So the only 2 witnesses for the defense were the sister saying the place was raunchy and the mother saying that. And
Final verdict form.
I don't know what the hell else she was trying to say with what she said. None of them could speak to what happened that day.
Verdict form that you guys have stipulated to.
There are gaming elements, though. The guy I worked with one time had a jury consultant watching the jury, and the jury saw that, noticed it, and played a game right back during the course of the trial, which was pretty funny. I think that they did that. They all started wearing the same color shirts on different days, and that sent the jury consultant into a big tailspin. But after the trial was over, they said they noticed they were being stared at by this person, so they just decided to do that, which was pretty funny.
This will be the final verdict form.
I think she's on her way there. That's what I gathered.
Mr. Miller? Thank you, sir.
Yeah, I agree. At least it didn't drag on. I mean, you can't say this trial dragged on, but yeah,
Okay,
I didn't like
so
it
now
either.
we're waiting on Ms. Imirowicz. I'm not sure what the delay is.
See, the judge doesn't even know.
Call, and I know there's a trial starting next door.
The judge just said she doesn't know why yet, but they're checking into it because they're going to want her there, when they bring the jury in and do the closing arguments. Which, the opening statements, my recollection is that the state did about 10 minutes
I'm gonna
and
step
the
off the
defense
fence
5 minutes. So I don't
she
think
gets
these are going to be
here. Before
hour-long
the jury
statements.
comes in, I will have you question your client, Mr. Miller, with regard to whether or not she's waiving her Fifth Amendment right to remain silent, or whether she wants to willingly, knowingly, and voluntarily take the stand. So we'll proceed in that fashion as soon as your client arrives. Okay?
All right.
Thank you, everyone.
Thank you.
Yeah. So the judge will probably have that conversation with her when she gets in there. If you were watching the case in Florida, the Peterson case, that's how I got back into this, witnesses and victims by Zoom, because the defense in that case was consenting to a witness against him coming in by Zoom. And the judge actually swore the defendant in and said, you're giving up a right here. This is totally bogus. And if I do it this time, doesn't mean I'll do it again. And you can't make any kind of appeal off of this because it's your choice. And the guy said, no, I understand, Your Honor. Basically, I think he is operating under the assumption the state will honor their agreement to allow his witnesses by Zoom, which I think they will. But the judge was clear that he's no party to that agreement. We get a good look at this device here. That's nice. Shout out too for the technical staff there, operating their gear pretty well. No major glitches on showing exhibits and things like that. And shout out to the jurors who were handling the lighting during the transition between showing exhibits and live testimony. They did a fantastic job. Well run. And once they fixed the audio that was turning off whenever a question was being asked and they went away from the witness, I think it was all presented pretty smoothly. So this case gets streamed. It was a little bit interesting to me. We're watching it. It's almost over. Does this help the public that this is on TV or being live streamed? Is it good or bad? I mean, to me, it's a little bit sad to have the dirty laundry. The worst things about this guy said on a stream, and he's dead and can't say anything in response. That's kind of the downside of it. The upside is you get to see how a case goes, and here's one that's actually fairly efficient. Yeah, I mean, in theory, you're going to say the state didn't meet its burden, okay, on one or more of the elements. They got to prove all the elements. So you want to attack the elements. So to me, the elements were, you can't attack the fact that it's not a chemical irritant. I actually did some legal research on this and saw a case that was reversed when a guy threw heated cooking oil, which was a dangerous chemical substance, the state said, but the Michigan Court of Appeals threw it out and said cooking oil is no more dangerous than water or anything else unless you heat it, and heating it is not a property of it, so it doesn't meet that statutory definition. But this one is coming in under the chemical irritant. They can't fight that, so they have to fight either the intent of an unlawful purpose or the unlawful purpose, or that the death resulted. And I thought with all he was alcoholic, his health was bad, that they may call an expert and say, well, he died for some other reason or whatever, but they didn't do that, and I don't think that would have worked. And they haven't shown that she didn't throw it, and the state has shown that she did throw it. She said she did. What's the evidence that it wasn't at least for a purpose to annoy, harass, or injure him in some regard? I didn't see that. So I don't know the defense at this point, other than get to sentencing and let's argue that she had a tough time growing up, didn't really mean for this to happen, and let's get the minimal sentence that you can convince the judge to do. That's what I think will happen. And some people have an intuitive sense of an element of the crime. Like Sarah Boone's like, well, I didn't intentionally do this. Unfortunately, while she thought she was dunking on the police by saying that, there's the reckless standard for the crime that she was charged with, the level of murder she was charged with. And you can be reckless without intending to kill. And here, she told the police, my brother's yelling at me. They're acting like I'm a horrible person. And I didn't mean for this to happen. I would never intentionally hurt my dad. I think she actually did say that at one point. So, yeah, well, intent to injure is just one way that you can come under the statute. Another way is to harass. So she was really not helping her legal case at all by saying the things that she said, in my opinion. And, if she should have put on a better performance right from the start that this was an accident. I didn't know this. No, I did not know it was a chemical irritant. I had no idea that it would do that. Oh my God, I can't believe this happened. I went to the hospital right away. What in the world is anybody talking about? You sure it wasn't something else? Do that, because then you could at least have a defense on intent. Like, I didn't know this was a chemical irritant. I didn't have any intention to do anything bad, other than sometimes we throw stupid things at each other. We're never hurting each other. It's not even harassment, because the way we communicate. Say something like that. Does anybody believe that? I don't know. But sometimes you only need one person out of 12 to do it. And you gotta run with what you brung. All you got are the facts she gives you. So you make the best argument you can. And sometimes you hear lawyers get super bombastic, and there's the old phrase of if the law's on your side, you pound on the law, and if the facts are on your side, you pound on the facts, and if you don't have either one, you pound on the table. And this lawyer has not really done that. I think the victim blaming was a little bit of the pounding on the table kind of thing, but this guy has not been pointlessly argumentative or anything like that. What he did say in his opening was keep an open mind. But okay, well, we did that, and there you go. Well, I think she did tell the police in that Bigfoot alien clip that's hard to understand, but the longer version, that she said, well, I thought it would only do it, the crystals by themselves wouldn't do anything. And then the police officer said, well, but you put water on him too. But it doesn't stop the fact it's a chemical irritant, and you have to get to the point, which I get what you're saying. And the argument from a legal standpoint of what you're saying would be, there was no intent to harass or injure because she didn't think it would cause any injury. But the backstop against that is, why would you pour a cleaning solution on someone, even if you didn't think it would send them to the hospital, unless you're at least trying to harass them, right? So I think she's just in a tough spot here, because this is not murder statute. This thing only has a couple of elements in it. It's a tough one to get out of.
Calling People versus Imirowicz, case number 22-281-519 FC.
So maybe they have the defendant now? Yes. Okay, so we'll hear her say, I don't want to tell this story out there in this trial. Yeah.
Thank you. Megan Imirowicz. Ma'am. I just received a change of the verdict form.
That's right, Judge. We just realized that the verdict form actually said count one said unlawful use instead of unlawful use causing death. I asked Mr. Miller about it. We're agreed that that's what it should be.
Yes.
So you want it just to say unlawful use?
No.
We want to say what it says exactly right there.
Unlawful use causing death.
That's
We amended it. They should have printed a new one out.
Guilty of chemical irritants, unlawful use causing death.
Thank you. I have it. And then in the chemical irritants at the top in bold, did you want that in causing death as well?
It should be, yes.
All right, so you want to make that change?
So that's it. You used a chemical irritant, unlawful purpose, or cause death. That's it.
With regard to testifying,
Your Honor, I talked to my client. It's my understanding that my client will waive her right to testify. And I would like to question her on that.
Ms. Imirowicz, ma'am, can you stand up and raise your right hand to be sworn, please?
Under penalty of perjury, do you solemnly swear or affirm that the testimony you're about to give this court today is the truth, the whole truth, and nothing but the truth? Thank you.
Go ahead, Mr. Miller.
Thank you. Would you state your name and spell your last name for the record, please?
Megan Imirowicz, MeganImirowicz.
Okay. Mr. Imirowicz, you and I have had the opportunity to talk about your testimony, correct?
Yes,
I've explained to you you've got an absolute right not to testify. You understand that?
yes,
You also can testify if you want to.
yes,
All right. Now, it's your intention at this point in time to invoke your Fifth Amendment right and not testify, correct? All right. And that's what you want to do.
yes.
Thank you.
Well, that's weird.
Okay.
This comment sums up my reaction. Well,
With regard to the verdict form,
It's
you've
been-
sent that over?
I have, Judge.
Okay, I'd like that printed, and I would like the lawyers to both look at it to make sure that's exactly how they want it. And then you're not calling any further witnesses,
I'm
is
not
that
calling any
correct?
further witnesses, correct?
Okay, so the defense is resting at this time.
Yes.
Okay, and Ms. Imirowicz, it's your indication on the record, ma'am, that you do not wish to put a defense on with regard to your own testimony, and that you're invoking your Fifth Amendment right to remain silent. Is that correct, ma'am?
Yes.
Okay, ma'am.
People won't be calling any rebuttal witnesses.
And there's no rebuttal witnesses. Okay. Yeah, it's not.
Maybe it didn't say quick.
yeah, I don't know if she's just nervous, but
Change.
I kind of agree with that. But she got asked several times, and she gave the same answer. It's her ball game now.
What I just sent.
Life comes at you fast sometimes.
Is that it?
She's looking a little nervous now. What if she jumped up right now? I said, I do want to tell what happened. So here's the thing.
Okay.
She doesn't have to testify, but at sentencing, you think she would want to speak to minimize the
Okay, we're ready for the
damage
jury.
that's going to occur to her on sentencing. Why not do it now? But, usually you don't have them testify, and that's what happened here. But I think her battleship, her Titanic is heading straight to the bottom on the guilty verdict. She is sunk, and it'll just be about how much punishment she gets. I mean, you don't, in the American system, you don't instruct the jury and you don't draw a negative inference from her decision to invoke her right to remain silent. It's not the same everywhere else, but it's the way it is here. Having said that, from a tactical, strategic situation, she's the only other person who could say, because her father's gone,
Called the case. We are on the
anything in her own
record
defense, really.
to put their appearances on. Mr. Miller, sir?
Your Honor, defense rests. We have no witnesses to present.
Thank you. And Mr. DeSantis, and rebuttal witnesses.
No rebuttal witnesses, Judge.
Okay, thank you. Ladies and gentlemen, all the proofs are in. Both parties have rested. The plaintiff, the people, will now present their closing argument to the jurors. You may move the podium if you need to.
I'm actually going to stay here if I can use the screen, please.
Sure.
Go into film noir mode. I wonder if he'll slow down the talking a little bit. He said yesterday he knows he talks too fast. Or fast. He didn't say too fast. Fast, he said. The thing is, I don't think any of that matters for the elements of this crime because it's such a weird statute. It's not a normal statute. But it would for sentencing. And I definitely think that's a place for all of this stuff.
Good morning, everyone. Thank you again for your time and attention.
Very relevant there.
This has been a long trial, and it's been a little bit disjointed. I acknowledge that. It couldn't be helped, I'm afraid. Now, this is going to be the part of this trial where I go over everything I presented and give you all those little puzzle pieces again that I talked about in my opening and help you put them together. So I want to start by talking about our burden of proof. This is my standard. A reasonable doubt is a fair and honest doubt, growing out of the evidence or lack of evidence. It is not merely an imaginary possible doubt, but a doubt based on reason and common sense. It's also not beyond any doubt or beyond all doubts. And we don't have to conclusively disprove any alternative theory because that would be impossible. It's always possible you can have 99.999% of a picture set, and that there's always, that little tiny 0.0001% chance that could come and screw it up. But that's not a reasonable doubt, right? It makes me think sometimes of when we put in DNA evidence. The lab techs always say it's something like a 1 in 100 billion chance the DNA on the murder weapon comes from someone other than the defendant, right? They don't say, yeah, it's the defendant's blood. They just say it's almost impossible for it not to be, okay? That's kind of what we're talking about here. It's possible, but it's not reasonable. In a case like this, I think the greatest assault you can make on the case we put on and the reasonable doubt here would be one of distraction. It's one that would get everyone on the jury, all of you, to miss the forest for a single tree. A pine forest is still a pine forest, even if there's another tree in it. I want to talk a little bit about the inferences. They are not only allowed, they are required. This is something that we do every day, and it's something that jurors have to do as well, because very, very rarely does a defendant stand in front of the people and tell them exactly why they committed the crime and what their intent was when they did it. And if they do, those cases even more rarely go to trial. An example I like to give is if you come downstairs in the middle of the night and you see your kid with his hand in the cookie jar. You know exactly what he's doing, right? He's getting a cookie. It's possible he could be doing something else with it, but it's not reasonable. He put his hand in the cookie jar because he's getting a cookie. There's no other rationale for it. Now, before we really dive into everything and I go over some of the evidence again with you, I want to remind you that two of the elements I do have to prove are the date and the venue. So the date in this case, of course, on or about October 1st, 2021, and that venue is Oakland County. I don't really think that's been disputed in this case, but I need to say it anyway. When I started, I told you that trials are a quest to determine what happened and if what happened broke the law, and it's your decision on those two things. That's your job. Everything else is for somebody else. So let's go over that now. Let's apply the facts to the elements. What happened? Here's the basics, I think, about what happened actually on October 1st, 2021, and what I think the evidence shows. It's Megan's birthday party. Life has not been easy necessarily at the Imirowicz household, and today is going to be a good day because it's her birthday party. So she gets up, she goes to get her dad to drive her to her hair appointment, and Dad, Conrad, is drunk. Probably again, right? This is not going to be the first time, and that's really not okay. Not today, not on this day, and she loses control. She starts throwing things at him. It's not helping her feel better. She's furious, out of control, and she goes way, way too far. And that's something that can happen to all of us. When we lose our temper, we can go too far. And so she grabs the lye, pours it on him, and pours water on him. A couple of hours later, Kayla finds him burned when Megan sends her over there to get the credit card number. She calls 911. Conrad's taken to the hospital, and after months of treatment and pain, he eventually dies from the burns and the complications thereof. That's the basics. So how do we know? Did it break the law? We have to apply the evidence to the elements. These are the elements of the offense. Unlawful possession or use of chemical irritants causing death. The defendant placed, used, or released a substance. The substance that the defendant possessed, placed, used, or released was a chemical irritant, which is a solid, liquid, or gas that through its chemical properties, chemical or physical properties, alone or in combination with one or more other substances, can be used to produce an irritant effect in humans, animals, or plants. The defendant possessed, placed, used, or released the chemical irritant to frighten, terrorize, intimidate, threaten, harass, injure, assault, batter, or kill Conrad Imirowicz, and that the possession, placement, use, or release of the chemical irritant resulted in the death of Conrad Imirowicz. Let's take them each in turn. Facts and inferences applied to element 1. Placed, used, or released a substance. This case actually differs from some homicides where we actually do have some statements from the victim to people. In his opening, Mr. Miller said that in this trial you would not find in any exhibit testimony, or even in, I think he said like the 20,000 some pages of medical records, you would not find a single instance where Conrad said that Megan threw chemicals on him. That we found out to be not true very quickly.
Number 1, what's the location of the emergency? This is Oakland County with a transfer at 1650 Duck Creek Lane. Okay, thank you. Hi, Paul, what's going on out there?
Hi, my name is David. I'm a nurse at Ascension Genesis in Grand Blanc, Michigan, calling to report a possible assault on my patient.
Okay.
My patient's name is Conrad, Konrad. Last is Imirowicz. He's a 64-year-old male patient with the date of birth of August 11th, 1957. Arrived via EMS with multiple chemical burns across his body. When he first arrived, he said that he thought maybe this was from a bug spray. Upon further investigation, the gentleman stated that his daughter had thrown some substance on him, possibly causing these burns.
Okay.
So David Backos' 911 call tells us what Conrad was saying, even then at Genesis Ascension, the first hospital he was there. Remember, he was in the room when he was talking to Lucas and to Austin. All right. Now, Lucas and Austin certainly know Conrad, and they have a ton of reasons to feel emotional about him and protective. But David doesn't, right? He's just a professional. Quite a professional, actually. I mean, I was actually quite surprised with the level and depth of his experience and how intelligently he was able to talk to you about what was happening. He has no stake in this game.
Number 1, what's the location of the emergency?
And because he's a professional, he also recorded this in his notes, in the medical records. These were on Exhibit 14. It just so happens to match, again, what Lucas and Austin were saying, and what Lucas told you, and what Austin recorded in his written statement, that Megan threw hair dye and cleaning supplies on him. That's what I like to call independent third-party verification. But if there was any reason for anyone to be skeptical of what Lucas and Austin remembered and wrote down before, their testimony is corroborated 100% by someone with no stake in the game. Patient recently called that the patient's daughter had thrown something on patient. Oakland County was called about the alleged assault. Poison control called, and for poison control, pesticide bombs normally present with respiratory distress. Poison control recommended standard tox screen and standard burn protocol. Let's talk about facts and inferences applied to element 2. The substance the defendant used, possessed, placed, or released was a chemical irritant, and what that means. Look, we know Lye did this to him. This was not a bug bomb. Even if you don't believe, let's set aside count 1, or element 1. Even if you don't believe Megan did this, or that she knew that it would do this, or the intent she had when it did this, it was the Lye that did this to him. And is Lye a chemical irritant? I don't really think we need to move past the bottle, right? Exhibit 9. Skull and crossbones on the front, big red label, causes severe burns. You can read more instructions. Precautions. Wear protective gloves, clothing, eye and face protection. Do not get in eyes, on skin, or on clothing. Danger. Causes severe burns and serious eye damage. It talks about do not mix with hot water. talks about if you do get on your skin, wash immediately with cold water. This is a chemical irritant, no question. And it's only made worse when it's mixed with, other things like water. And I would say that even in this case, calling it an irritant, given what we saw happen to Conrad, is something of an understatement in the legal phrasing. But it is certainly an irritant. Facts and inferences applied to element 3. That the defendant placed, possessed, used, released the chemical irritant to frighten, terrorize, intimidate, threaten, harass, injure, assault, batter, or kill Conrad Imirowicz. So listen, this is a homicide case, right? And that word homicide comes with a great deal of pressure and weight upon your determination and what you think. You think the word murder, and then the brain can come alive with ideas of what that means. So I want to talk about intent and killing, and I want to do this by breaking down the video where Megan talks to the police. It's a little hard to hear because of the static and the technology. So I've chopped it up into little bits. We're going to go through most of the video that I showed you in smaller sections and smaller portions to keep it easier to track. And then we're going to, apply to this element and, of course, some of the others while we do it. So this section is 2 minutes 45 seconds to 3 minutes in the video. All right. I don't know why it doesn't play.
Naturally, that doesn't work when he's in the middle of his closing argument. He's handling that well.
Give it a second. Come on, Trish. You run this 9 times yesterday. It runs fine.
Our courts are going all electronic here too, and see this happening more and more.
I started yelling at him and crying because obviously that's the part of me,
Absolutely.
stop drinking and it breaks my heart.
Absolutely, it's tough. I totally understand.
Looks like the mother back there in the background, in the green. Isn't that her? Or am I wrong? Somebody said she was on a stream earlier. I don't know if she pre-recorded it or did it before she came in here or what.
I started yelling at him and crying because obviously that's the hard thing,
Absolutely.
stop drinking and it breaks my heart.
Absolutely, it's tough. I totally understand.
And I just kind of got mad and I'm like, all I threw at him was a bag of rice. And
So this is very, very early on in the process, right? And the first thing she goes to right away is, all I threw at him was a bag of bread. They hadn't even asked her, what she did, really. They hadn't told her, did you throw anything on him? They hadn't suggested a single thing to her. They had just asked her, tell us what happened. And she goes right to, I was throwing things at him. And she goes right to, minimizing her culpability. So she's talking about Kayla now, and how Kayla came over and did this and called it. Now, remember what Kayla testified to, though. Kayla testified that when she called Megan and told her that he was burned, she kind of just scoffed and hung up the phone. And then she called Austin, and Austin told her to call 911. So what she told the police here is already a lie, right? Kayla has absolutely no reason to lie about this. Let's not forget that Kayla was one of Megan's friends. She was going to the party that night. She's the person she trusted to go back and get the credit card information to pay for the hotel room. Kayla didn't take the stand and lie to you. One of them did. One of them lied to people, right? It wasn't Kayla on the stand. It was Megan to the police. She's trying to make herself look better here. And that was, by the way, 3 minutes, 30 seconds to 3 minutes 52. to move on to 3 minutes 54 seconds to 4 minutes 25 seconds.
Like, my mom called me and she was like, Megan, did you do this to your guy? And I was like, no, I didn't. I would never intentionally hurt my own father, and it kind of sucks that they all think I would. But I could never do that to him. I didn't. There's a lot of stuff over in that area, so it could have been over there since our house is a mess. And
What could have been over there?
they said chemical burns, so I don't know. But I know there's a lot of stuff over there. I don't clean it up because I shouldn't have to be beat up on.
All right. So she's already saying I never intentionally would hurt him, right? We already admitted to throwing things, but now it's I wouldn't intentionally hurt him. She's already protecting herself. She's already making an excuse. And I want you to remember that part where she says, there's lots of stuff over there. There could be lots of stuff over there. Because that's going to come back later.
I never clean how they're said. Maybe it's like I do like food. There's only ever food around there. I could never usually throw something dangerous out my own pocket.
So now there's only ever food around there. There's no cleaning products for me to grab. That would be crazy. Why would there be cleaning products there? There's only ever food. That was 6 minutes 13 seconds to 6 minutes 23 seconds. So about 2 minutes later, she's already losing the thread.
Okay, is it possible that you threw some other things aside from blood?
I mean, it could be possible. I don't know.
7 minutes 13 seconds to 7 minutes 20 seconds. We're now at the point where, okay, it could be possible I threw something besides the thread. It could be possible there was other stuff there.
Do you remember throwing anything at him that caused like this white powder to not intentional. We're not saying you intentionally tried to. We're trying to figure out what she threw. This is kind of.
I don't think so. I mean, there was like liquids, but there wasn't
What kind of liquids? That's the detail we need to do.
probably like water or something. Like I don't remember.
Like a water bottle or like a cup of water.
It was in a bottle, like bottle water.
Okay. And that's still on there?
So we went from bread, nothing but bread, to could be other stuff, it could be possible. Now it's liquids. And by the way, she was specific. It was a bottle. Right? It wasn't, yeah, I don't remember what kind of liquid it was or what it was in. It was a bottle. She knows. And that was 7 minutes 38 seconds to 8 minutes 11 seconds for the record.
Going on. So do you want to restart and tell us what happened? Okay, so what happened?
So I was throwing things. I was just grabbing anything that was on the floor. And then I just got like, I got tired of it. And I went to like,
So she was just grabbing anything around. That was 8 minutes 41 seconds to 8 minutes 57 seconds.
Okay. When you were throwing stuff, right? You're unintentionally throwing stuff. Not, you know, just, I understand, totally get it.
they're not at him, it's
Sure.
around him.
Right, that's fine. When you threw anything, because we need to help the hospital out here. They're trying to figure out what's going on because, like I said, he's in rough shape, okay? Was there any white substance that flew out of something when you threw something at him or anything? We're trying to help your dad out here.
I think so, yeah.
Okay.
9 minutes 37 seconds to 10 minutes 5 seconds. It took less than 10 minutes for her to admit that she threw things that involved white powder, which we know was the lie. Had to be. And I thought it was interesting because even when she's doing this, she's still trying to protect herself because she's talking to the police and she knows she might be in trouble. That's what she said at the very, saying at the beginning. I don't want to get in trouble. Because she's saying I wasn't throwing it at him, I was just throwing it, near him. When you're throwing something at someone, unless you're playing sports, you're doing it because you want them to hurt or to feel something of the pain you're feeling because you're angry. You want them to experience what you're feeling to some degree. Throwing it near them doesn't do anything. That's not true. Right? No one throws something near someone when they're angry. Unless you're specifically trying not to hurt them for some reason. But that's not what happened here. It can't be. Not with the level of injuries we have.
Was he wearing a shirt? Remember? Shirt or pants? No?
I know he wasn't wearing pants, he was never.
Okay.
10 minutes, 11 seconds, 10 minutes, 19 seconds. I know he wasn't wearing pants because he never wears pants. That would make sense given the injuries we saw. The legs were worse, right? That's what the doctors told us, and that's what's pretty evident.
Where on the body did you see that white stuff?
It mostly went on the couch, a little like on his like lower legs, but it was mostly covered with blanket.
So 10 minutes, 20 seconds, 10 minutes, 29 seconds. It mostly went on the couch, a little on his lower legs, talking about the white stuff. You know, how would she know that if she didn't do it? Right? She knows where it went, and she's still trying to pick herself because she says there was a blanket in the way, which is absurd. Most of it didn't go on a blanket or on a couch. It was all over it. We saw. The back of that one leg that's in that photo was completely black, from heel up to the end of the leg. So most of it didn't get anywhere on the couch. And we saw the couch. There was a little bit on the couch, right? There was a little bit on the blanket. But look at his body.
You know what that stuff was?
It looked like something for the tub or something. You know,
Okay,
I
all
don't
right.
think so.
Do you know what that stuff was? It looked like something for the tub or something.
Well, that's terrible. I couldn't make that out
Ever
earlier.
use that stuff to clean the tub? So like drain them all, like lie.
Like when I think for one of them. I think it's for one of them. It's like my dad uses it sometimes to like the clog.
Do you ever use that stuff to clean the tub? I think my dad does. You know, like Drano Lie. Do you ever use that stuff? I think my dad does. I think he uses it for one of those things. I think he uses it to clog. I think she means declog. Right. But she knows exactly what it is. Okay? It's 10 minutes, 41 seconds, 10 minutes, 54 seconds.
You know what that stuff does to someone's like skin? You don't know? What do you think of it? Feels good if you have that Drano type of stuff on your skin?
Do you know what that stuff does? Do you know what it's like to have that skin? Do you think it would feel good to have on your skin? This thing is easier to hear by headphones. I don't know if you're going to be able to have it in the back. So there's really two options here. Either she says something very, very quietly, or she doesn't say anything of that at all. Which would be the only time that she doesn't answer a question, basically, in this whole interview. Right? That suggests to me that she knows that it's not going to feel good. Because, of course, it doesn't. She knows this is stuff you use to declog a drain and clean a bathtub. She knows that this isn't going to be something you want to put on somebody. And even if she doesn't, you know, the bottle will tell you.
When you threw it on, was he just motionless sitting there?
Yeah.
He didn't try to wipe anything off, so it kind of just soaked into his skin, right? And then you took off. Is that the extent of kind of what happened?
So he was motionless. That was 11 minutes, 12 seconds to 11 minutes, 24 seconds. We know that he was drunk. We know he was very likely passed out. So she did this to a person who was unconscious, asleep, and couldn't defend themselves, and couldn't move, and couldn't take action to even clean it afterwards, right? This is an intentional act. This isn't something she's doing even to convey the kind of rage to him, because he's not even awake enough to see it. This is something to be done for him to feel later.
Were you concerned that there was white powder on him that maybe would have ate through his skin?
I didn't know it would do that. I thought things like that just kind of sat there, nothing was happening. I thought.
I didn't know it would do that. I think things just like that sat there and nothing would happen. That can't be true. We know it's not true. Everything indicates that's not true. But what it does indicate is that she did do it, right? She was throwing it. She knew what she was throwing. Because I didn't think that would happen. That's her saying, I did it, but trying to protect herself.
I guess my question to you is, why didn't you tell us initially the only blue thread? What were you afraid of that was going to come out?
I don't want to get in trouble for something I would never purposely remind doctor.
So this is where the police are starting to talk to her about, why did you lie to us at the beginning? right? Why did you tell us it was just Fred? Why didn't I throw anything? And she's still trying to protect herself by saying, I didn't do it purposely, which is the defense that people do when they can't accept the responsibility for their actions, right? I did something because I was angry, upset, and I meant it at the time, but now I have regrets. Regrets are fine, regrets are good. We should have regrets when we do bad things. That doesn't change the fact that there has to be responsibility and accountability for the things you did. And it also tells us that the moment the police showed up, she knew that there was something wrong, right? She already tells in the video that, they told me it was chemical burns at the beginning, so people have called her already, right? They told her, Dad's at the hospital. He's got the chemical burns. They show up, she knows why they're there. And she is immediately defensive.
Did you think that what you did today might have hurt him when we came here? Is that why you weren't telling us everything that happened?
Well, I knew because obviously, like, my brother's yelling at me, like, everyone's yelling at me because they think I'm this wrong person, and it's like, I didn't intentionally do that. And I just I don't want to get in trouble for something I never meant to do. I didn't think it would hurt him.
This is one of the parts, I think you can see kind of the frustration of the officers here, because she's still trying to pretend that she had no idea if this was going to be a bad thing, right? But there's no question. There can't be any question. When you watch the video and break it down slow, and you think about what you're saying, and actually take a little bit by bit, it is extremely obvious that this is an action she did, that she knew she did. She knew what she was doing. She knew what she threw. And it's absurd to suggest that she thought that this would be just fine. And of course, it wasn't just to the police that night that she admitted what was going on.
Friday morning, I'm gonna send this in a video because I don't feel like texting, but Friday morning I woke up and I went to go see my dad because I had hair appointments, so I needed him to take me. And he was drunk and I was like upset because he's like an alcoholic and we wanted to stop and everything. So I threw a bag of bread at him because I was angry. I'm not gonna throw something that's gonna hurt him. And I threw a few other things, but I threw it like at the end of the couch so it like wasn't near him. And I left. And when I left, I said goodbye to him. He said goodbye. And then I needed his like card info for the hotel because I was going to a hotel for my 18th birthday. And then I had my friend Kayla, go to my house because she lives down the street to get it from him. And she was like, Megan, your dad's not okay. And I was like, what do you mean? And she was like, there's like burns on it. And I was like, what? Like, I was so confused because I was like, why is he, like, what is happening? I was like, my instant thought was he probably like stood up and fell because he's prone to hurting himself when he's drunk. And I'm always the one who has to go and help him off the floor and make sure he's okay. So I was like, call my brother. I didn't know what to do, so I just told her to call my brother, and they called an ambulance. And it's like, apparently there were like chemical burns on him, and I'm like, I was so confused, like, I don't even know what's happening. And then my brother's like yelling at me, saying, I didn't do it. When I left, he was perfectly fine. I would never intentionally hurt my dad. Anyone that knows me knows that I'm against violence. That my dad's like my best friend. I've never hurt him. And my brother wasn't even there. And Lucas, Kobe, and Bella West over here are like, since they're our best friend, they were like talking to the police, and they were like, yeah, Megan did it. She did it. Were you there? No, you weren't there. Neither was I. Nobody knows what happened. But they all blamed me because people like you in this world don't know how to shut up. And so they all they blamed me. They said it was my fault. I wasn't there. I didn't. The cops came to the hotel I was at, and they were like, so your dad is severely injured. He's in the hospital, and everyone's saying you did it. You mean everyone who wasn't there? Is that so? Because what? And they were saying, like, my mom said that my dad didn't know what happened. He didn't know. Like, so how are y'all gonna arrest me for that shit? So they took me to jail. Even though I'm fucking innocent.
that's what she sent to Blake Shelton about a week after this incident, right? Yet again, she's trying to tell the same kind of things, deflecting, saying she didn't do it intentionally. I hope you noticed that not once did she ask about how her dad is. Not once did she express concern for his well-being, the man she says is her very best friend and all that. It's a lot about her needs and what she's worried about and becoming the girl that she thinks she can be. So let's talk about intent in homicides and what did Megan intend to do. There are a number of homicide charges in Michigan, okay? First-degree murder requires premeditation and deliberation. It's the intent to kill and only kill, nothing else, right? The classic examples of this are like if you sit in the back seat of someone's car and wait to ambush them, or poison them, something like that. That's not an intent you have to find here. Second-degree murder. Intended to kill, or intended great bodily harm, or knowingly created a very high risk of death or great bodily harm, knowing that death or great bodily harm would be a likely result of her actions. That's sometimes called depraved heart murder. Okay, this is someone whose actions are so reckless that they have to be criminal, and it's just absurd. One of the classic examples of this one is if someone's playing Russian roulette and slips a bullet in the gun, right, with their friends. You don't know who does it. Voluntary homicide. It's the same elements of second degree for intent, but it has to be triggered by some intense event. The classic for this one is when you stumble upon your spouse and they're cheating on you. And you snap and you kill one or two of them, right? That's voluntary homicide. Your charge is not that. It's none of those. You don't have to find an actual intent to kill ahead of time. You don't have to find that she did this with the desire to kill him. Just that she did it with the intent to frighten, terrorize, intimidate, threaten, harass, injure, assault, batter, or kill. I'm not playing video. Actually, I just want it to be, 1 second, Judge, I just want it to be on one mode now. The intent on our charge. Of all those options, right, to frighten, terrorize, intimidate, threaten, harass, injure, these are all things that have pretty standard definitions. Any of them can work, you know. Intimidate, this could be done to intimidate. After he wakes up, right, he was behaving in a manner that she didn't like, that was pain, that caused her a lot of anguish. And so now it's you're going to do change. Look what I can do. Look what I will do. Look what I have done. It's time to change. To threaten. Look what will happen if you don't. Right? To injure. That's certainly something that was done here. Or to assault, batter. Right? That's an attack. To do something when you're trying to cause someone harm, and to hurt them, but maybe not kill them. You don't have to find intent to kill. I think you can. I think there's enough evidence to do that. I think when you look at the burn patterns and the injuries, which I'll probably go over later, you might be able to find intent to kill here. But you don't have to. And the thing is, you all don't have to agree on which intent you find. One of you can think it was intent to kill. One of you can think it was to intimidate. One of you can think it was to frighten, because I bet when you wake up and you have burns like that over, it's scary as hell. Certainly Austin said it was scary, and that his dad was scared when they were at the hospital. You don't have to agree on which one.
Okay, so you're in my shoes, right? How old are you? You just turned 18. If you were to throw, and to be honest, truth, if you were to throw Drano, household acidic cleaners on someone's body, what would you think that would do? I mean, we're both smart individuals. It's probably pretty.
I didn't think like the powder alone would do that.
Well, you said you threw water too, right?
Yeah, the water.
fire and the drain was. Okay. So, at this point, I'm going to have you turn around. You are under arrest, okay? All right, so turn around, place your hands behind your back, okay? We'll try not to make it.
She knew what she was doing. And she knew what the intent was. And it was so preposterous that the trooper here, after not even 15 minutes, was already, rubbing his head like, are you serious with this stuff? Can you really be still trying to say that you didn't know that this would happen? Or that something would happen? This gets us to the last element. That the possession, placement, or use or release of the chemical irritant resulted in the death of Conrad Imirowicz. I don't really think there can be a dispute here. I don't really think there is a dispute here, frankly. But let's just go over it again. Dr. Varane, perhaps the expert of all experts in homicides and in forensic pathology. 20,000 some autopsies, right? 31 years. Cause of death, chemical burns with complications. Manner of death, homicide. The 64-year-old white male Conrad Imirowicz died of chemical burns with complications. He sustained these burns when caustic chemical was thrown on him. He survived longer than 5 months of medical treatment for these burns. There were no other physical injuries. The manner of death is homicide. The only other alternative that's been posited in any of the evidence in this case is this idea of the bug bomb, right? Now, everybody up there told you that this couldn't be a bug bomb, and certainly that there would be some injuries to the lungs. There were no injuries to the lungs. First, these are the Hurley medical records, page 45. There is no associated inhalation injury. It's not there. And then when it came to Dr. Varane, there was the scarring on the lungs, which she said could only be a result of repeated infections, which is what happened here. Conrad spent 5 months at the hospital. 5 months in which they were trying to save his life. It was 153 days he was there, and after he went off life support and went home, it took him only 3 days to die. He got 3 days after 5 months of horror. The elements in total. The defendant placed, used, or released a substance. No question. She admits it. The substance the defendant possessed, placed, used, or released was a chemical irritant. This is perhaps the least arguable element of them all. The defendant possessed, placed, used, or released the chemical irritant to frighten, terrorize, intimidate, threaten, harass, injure, assault, batter, or kill Conrad Imirowicz. There is no other reason you pour Drano on someone's body unless you are trying to do one of those things. And if you do it on accident, you clean it off right away because you know what it is. And that's what's crazy about this most of all. She put this on him and left. Right? She put this on him and left and had no reason to believe anyone was coming back. The only reason Kayla went back is because she called her and needed the credit card. But there was no reason that this passed out man unconscious was going to have anyone come and help him. So she just left him there like that. She didn't clean it. The only option that this wasn't going to get very bad was if he woke up from his drunken stupor. And this is a girl who's doing this because he's drunk all the time. She knew what this was going to do. She left him to burn. And that the possession, placement, use, or release of the chemical irritant resulted in the death of Conrad Imirowicz. I want you to think about all the evidence in this case and all the burns, and whether or not there's actually any dispute to any of these elements, really, from the defense that was put on. Listen, the burden is mine, okay? I think we've met it, but since they did call witnesses and they did cross-examine and ask questions, I get to talk about what they said and what it implies, and what the defense is. Did anything that they put on, or any questions they asked, or the answers that came with those questions is the evidence you consider, not the questions themselves, did anything call into question what happened? No. Nothing actually called into question if Megan was there, if she's the one who did it, what was done, the damage that was caused, the knowledge or intent. Nothing. There's not a factual dispute. And so what happened is over. And now it's did what happened break the law, and there can't be a dispute there either. Ladies and gentlemen, I get another chance to talk to you in a little bit after Mr. Miller goes. And so we'll see what is said, and I'll respond to that, and maybe talk a little bit more if I think it's necessary. But I think we met our burden here. I think this is one of the worst cases I've seen. I think the injuries speak for themselves, and I don't think there can be a question about guilt. She wanted to hurt him because she was angry, upset, and she did so in a truly terrible way. And I think she's guilty. And I think the evidence shows she's guilty. And so I'm going to ask you to give her the consequences that I talked about in the beginning. The consequences of her choice to hurt him. And find her guilty on count 1. Thank you.
Jeez. Yeah.
Well, it's been a while on
So
that.
you ready for me?
Slow down a little bit. And now it's
Ladies
the
and gentlemen of
defense.
the jury, this is my last opportunity to speak with you. Mr. DeSantos gets one more shot. I want to thank you for sitting here. This is not one of the most pleasant cases in the world, but I want you to take a look at everything first and listen. I want to play the video of Conrad Imirowicz.
Right now?
Yep, I'm ready.
Okay.
This is what the victim had to say, and it's rare you get a chance to see what the victim has to say.
Yeah, I'm just going to start from the beginning.
That was close, but
She wanted to go to the beer. I get a new place. I couldn't get her in for whatever reason. So we were going to go to a hotel. Then she wanted her hair colored. She's got really dark hair. Lumpy black, like your mask. And it's very hard to color.
So you got a pacemaker, right?
No.
No?
No.
Alright.
I have nothing.
Nothing in you at all?
No.
Do you mind if we go in your house?
But go ahead. Door's open. And so I don't know. Last night I noticed she threw a bunch of stuff at me, got mad.
What do you like stuff meaning?
There's she rearranged her bedroom, so there was a mattress on the wall. She heaved that and went crazy on that stuff. So I've asked her to take out the garbage several times, and that hasn't been working. But
Is this kind of, I'm trying to gauge this. Is this a normal behavior that she would throw stuff on you to burn you?
no. She usually gets an argument. I get mad at her, she gets mad at me, we badmouth each other. It's not normal, right? But this is very, very deep. So last night I had half a Smirnoff. Put the bottle down. Put it back up.
The Smirnoff?
No, the little one.
Oh, the airplane size?
The Smirnoff, what do you call it? Ice.
Oh, beer, like the beer thing.
Beer thing.
Yeah, like the seltzer.
The little seltzer, right?
Sure.
The lemonade. So I have to watch a movie, shut off my phone, all in the night, pretty early. And then this morning, I got up, finished my Smirnoff, watched the rest of the movie, went back to bed. And they said, I got all kinds of people in the house with still,
Were you sleeping when this happened, or were you unconscious?
No, I was sleeping. I wasn't unconscious. I didn't have anything to drink. I have half the Smirnoff. Give me a break. I was thinking about getting her some breakfast and stuff, or making some. I was going to get her a breakfast because I was got the 2 for $5 thing going. Keeps, so I was going to do that. So you can go to my move if you want. Okay. All right.
I won't bother you that much. If you don't remember, you don't remember. All I just want to know if we can go into your house to investigate what happened.
Go ahead. The door is open, right, Austin? That's what I want.
The door is open. Yes, I have us.
There's a bunch of cats.
Let me talk to him and then we'll talk out there.
All the cats can go out except for a little gray one. I mean, she's tiny.
Right.
Padawan, she's not old enough to go outside yet.
Okay.
I mean, but they're.
Do you mind if I see your hand? If you just want to flip it.
My leg. Pull this cover off. I can't. The legs.
Carefully show
The legs.
Are you wrapped up in this?
Yeah, good.
I didn't know if you were wrapped in like a bunch or what. Can you see that good enough, or do you need a little more? Okay. It's like this.
The side.
Yeah. He gets to the food. Is he okay to lift that up like that?
You feel it.
All right. Do you have it on your back? You don't have to get up, but I'm just asking. Okay.
It's probably there. I don't know. I you can see my shoulder if you want to full back.
It's okay.
I showed him the pictures that I took.
Yes, you can.
Perfect. Okay, I will. I appreciate it. You get better, and I'll keep in contact with your family. Okay.
All right, awesome.
Yep.
All right.
All right. Bill.
That's all I'm going to show so you can hit the lights back, okay? Thank you. Very good chance to see the victim make a statement. His statement is that he was asleep, he doesn't know who did this, he doesn't know what happened, he was intoxicated. Well, actually he didn't say that, did he? He only had one Smirnoff off ice, but they told the trooper that it was a .3, which is close to 4 times the legal limit to drive. Now, if we go over the witnesses, Kayla said, I got communication from Megan. 10:30 in the morning. That's when supposedly all this happened. But based upon her statements, if I remember correctly, she didn't leave till 2:30. Now, she also said in her little interview she had talked to her dad. If you remember him, he remembers the incident, and he remembers her throwing things at him, an argument. He got up afterwards. He watched a movie, had the last of his Smirnoff Ice. That's what he said. Now, it's unfortunate that the troopers didn't get any fingerprints, didn't take a look and see what liquids were there, didn't do any investigation into the house. Basically, the troopers are there. They know he's burned. They know somehow this got on him. I mean, the officer in the tape says, yeah, we're looking into this to investigate. Is this a self-inflicted accident, or did you pour it on here? Now, let's think about this. She's 18 years old. This is her birthday party. This is 12:30 at night. She's already aware that her father has chemical burns because her brothers called her and contacted her. She's already aware of what's going on. They go there. She's cornered back in a vehicle with her back to the vehicle with 3 officers on this side. She's 18 years old. She's at a party. Did they look at her and say, well, you know, how you doing? Is it okay? They cornered her and put her in the car, put her there so they could get what they wanted, a confession, so they wouldn't have to do any more investigation. She's 18 at a party. And did they check for alcohol? Did they look at her eyes? Did they do anything? No. They said they went there to investigate. They asked her. She said, this is what happened. They weren't happy with that. They kept going. They pushed this. Their job's to close this case out. Their job's to get a confession. And that's what he got. He wasn't happy till he got what he wanted. He went there to arrest her. That's what we've got. Now, Mr. DeSantos said that in those medical records, you'll find statements made by Mr. Imirowicz blaming his daughter. No, you won't. Nowhere in those medical records does Mr. Imirowicz blame his daughter. Everyone assumed it's her. She lived there. They assumed it was her. They did no investigation. They did nothing. Close their case out. They're done. There's liquid on the floor. They didn't find out what kind of liquid it was. Although his ex-wife testified she went in there and there was a bag of feces at the thing, at the couch. It was liquid on the floor. Frankly, it's probably his urine from sitting there. The couch was in bad shape. Nobody tested it. There's fleas. The bathroom downstairs in bad shape. This is a house that is a nightmare. This is a house I hope none of you ever have to go into. This is a bad situation. There's trash bags all. They have to move the trash bags to get up the stairs, to get him down. She indicated she threw some stuff at me. Yes, she did. This is 10 o'clock. She indicated to Kayla again, can you come get me so I can go to the party? And then she got another text that said, oh, I got someone else to pick me up. She was gone. Now, it's true. She needed to get the tab or the credit card information. It's true. She called Kayla. Can you go over to the house? You live there. Kayla went over. Kayla said she's walking up the stairs and Mr. Imirowicz said hi. And then she got there and she saw the situation. It was a bad situation. This is 3:30, 3:45. If Mr. Imirowicz was chatting, he still was drunk. Because at that point in time, he didn't have any more to drink. They came and got him. It's 3:45. At 9 o'clock, we know his blood alcohol level was a 0.3. Very high. He didn't have anything to drink, we know, from 3:30, 3:45 to 9 o'clock. Now, if they're saying that this occurred at 10:30 in the morning, he would have been unconscious all that time. How much would have he had to drink? Where he wouldn't have been alive. It's not possible. But remember, he was doing something about a bug bomb. There's fleas in the house. Again, not a good situation. What did he do? He got up, he watched his movie, he had his Zima, or not Zima, excuse me. He had his ice, supposedly. Even the trooper said, look, he had more to drink than that. That's not possible. So, who put it there and what happened? The house is an utter disaster. You know that. It smells bad. You know that. There's stuff all over the place. They didn't look for anything. They didn't do anything. They had their answer. Okay. I'm going to ask you to take a look, if you want, at the medical records. You won't find anywhere in there where he says she did this. It's not there. The nurse didn't testify that he said it. It's based on everyone else and what he thought. Something occurred. Clearly something occurred. Someone might be to blame. Who do we got? Well, Megan lives there. We know she was around at some point. Blame her. It's possible. Troopers went out with one goal. Get her to confess. Their case is over. What happened? Well, if you'd have poured that stuff on at 10 o'clock in the morning, I doubt he would have been alive. But we don't know because we didn't test anything. We don't know how long it was on his skin. We don't know where it came from. And by the way, they're saying it was spread over him. Nobody said anything about her hands being in bad shape. The hands that were in bad shape were Mr. Imirowicz's. The only way those hands get in bad shape if he's spreading it around himself. If he's rubbing it in or moving it around or doing something with it. You look at the jar, there's still stuff in here. Still some of that chemical in there. All right? It's still there. Whoever had to throw it clearly had to get something on their hands. Or did he dump it on himself? His hands are in bad shape. Hers aren't. Nobody said anything about it. This is a man who is, well, I understand he passed away, and this is involved in. This is a man who, when he was married in 2007, was on medication for high blood pressure. Clearly, he's an alcoholic. He had liver problems, which healed. He clearly had kidney problems. He had some bladder problems. His son moved down. He's got some issues going on. He's not in good health. Shows up to his son's graduation ceremony, half his head shaved, dirty, really intoxicated. He's an alcoholic. He doesn't remember what happened. He remembers something about doing something with the bug bomb. Was it the bug bomb? Was it this? What happened? You got to look at it and try and figure it out. I'm asking you to take your time, think about it. Take a look at the exhibits. Remember what was said. Think about it when you were 18. What would you do if you're backed into a corner? You got a car behind you, 3 officers around you. It's night. You know your dad's been hurt. I'm not taking the first answer. They're not taking the second. They're going to keep going. You were at a party. What kind of condition are you in? What's going on? You're afraid. Your brother's already called you and said, you did this, Megan. This is a difficult situation. Nobody's saying she intended to do anything. Well, Mr. DeSanto's actually saying, yeah, she intended to kill him. I don't think so. You get to reconstruct. You are the trier of fact. You are the ones who will make a determination. All right? Now, when you go back to the jury room, you're going to be able to take a look at all the evidence. You're going to take your time. A couple of you are going to be dismissed, and they'll sit down, you'll figure a foreman out, and you've got to look at the whole situation. You saw Megan's tape that she made. Is that the truth? Is it a lie? She's under no pressure. She's trying to talk to a friend. That she's in front of 3 officers. You can see lights behind her, dark situation. They never checked. They never asked her. They never advised her she had a choice. They never did anything other than get what they wanted and what they wanted her to say. They knew what they wanted. They suggested, well, what about the white powder? said she threw a bottle with water. And this house, I wouldn't want to be in it either. They didn't go in, they didn't do an investigation, never found the top. Never found where it was at, never found what it was used for, never found out how old it was. Never looked and see where it was bought at, never looked and see how much was in it, how much was left. Never questioned anybody about it, never did anything. No prints, nothing. It's Megan did this, let's convict her, let's get it over with. Well, that's not necessarily how it works. Now, ladies and gentlemen, this is a tough case. There are some really nasty pictures here. I'm going to ask that you look past them. There's injuries, no question. There's damage, no question. Look past that. Look at the whole situation. Try and figure it out. They're all saying this happened at 10 o'clock. Mr. Imirowicz didn't say that. All right? He said, yeah, I remember was throwing stuff and everything. And then we were done. We had a little spat. He then went and sat on the couch, had his Zima, or I keep saying Zima, I mean ice. It probably tastes as bad either way. I don't know. All right. But you've got to take a look at the whole situation. Remember what he said. And yes, they came down and they arrested Megan. She made statements. She's backed into a corner doing what she's got to do. Officers are doing what they have to do. She knows there's chemical burns because her brother's already yelled at her. They're looking for that information. Nobody told us what was on the skin other than the chemical. Nobody said there was any water on it. Nobody proved anything else on the skin. Nobody indicated how long it would take for these burns to last. Nobody knew how drunk he was, what he was drinking prior to. We know he was at the hospital. So that was a 0.3, and you saw him talk. That's a 0.3, and he's doing pretty good. When you deliberate, please take a look at all the evidence. Take a look at everything else. Figure it out. I mean, clearly, things are thrown. Clearly, there's a domestic situation. Father-daughter, they're living in the same house. There's an argument. Well, they argue a bit. I remember her throwing things. He doesn't say anything about chemicals. He got up. He had his, he put off a bug bomb. That's a little odd. What else did he do to try and clean up? Why else was the lie around? Everything was up there. We don't know. They never checked into anything else. There's no other statements by Mr. Imirowicz. There's nothing else you can find. It's a difficult situation, but beyond a reasonable doubt, is she the one that did this? I don't think you'll find that. I think you'll find it for the domestic assault, there's no question. And clearly it happened in Oakland County. Clearly it happened on or about that date. No question. I mean, it shouldn't take much for you to figure out. I'll stipulate to it. Doesn't matter. I agree. But what Mr. DeSantos and I say are not facts. They are not what count. What the documents, what the evidence, and what you make a determination of is what the facts will be. That is your job. I'm asking you to take your time, think about it, and do your best. And don't change your mind just because you want to get out of here.
You have to figure out what you want, what you believe justice is, and make that determination. You already know the situation. You know the house is terrible. You know it's a divorce situation. You know the family's got problems. Mr. Imirowicz's son is an angry young man. I might be too if my father had gone through this. I don't know. It's up to you to determine. Ladies and gentlemen, thank you for your time, your patience, and I wish you luck. Thank you.
Thank you. All right. I want to take a couple things in turn. And the first thing I want to talk about is the idea that no one, or Conrad, ever said that Megan threw chemicals on him, except he did. He said it to Lucas and Austin, and it was heard by the nurse, David Bodges. And that's what he said. David Bodges said, I was in the room and I heard him say that, Conrad say that. So it's difficult to remember testimony from a couple of days ago. I understand that. It's hard. But that's what he said. I was in the room and I heard Conrad say that. This is not secondhand information that kicked this whole thing off. And it was David that reported the assault and started this. It wasn't Austin or Lucas. It was the nurse with no stake. Okay? One of the other big things that counsel focused on was the interview and the police and her just, taking what's going on. Apparently, if a police officer goes up and asks someone a question, they have to take the first answer that's given. And they're not allowed, apparently, to say, okay, well, that's what you say, but what about this other stuff that was there? Because that's what's happening, right? It's not a suggestion that there was white powder. They're saying, okay, but there was white powder there. What's your explanation for that? That's not telling her what she's supposed to say. What Megan did when she was talking to the officers was took an explanation from them that was less serious than what she did. And I'm going to explain why. So I talked about the elements and how all that, what came before, was absolutely enough to convict. Okay, Megan's version of this, when she was the most honest, right, was near the end when she's actually admitting that she threw stuff at him. But it's actually quite worse. Excuse me. All right. So I want you to see. Let's take a look at Exhibit 1 here and Exhibit 2. Let's take a look at the scene. This is the couch. Left side. All right. If you take a look up here, you can see some white powder substance. If you take a look over here, you can see a pack of Smirnoff Ice, presumably a Smirnoff Ice bottle. The bottle cap for it's right there. You can see a table or a chair here, all right? This is all completely blocked. These are all like food products and clothes. Okay. The other side of the couch. There's another couch, right? Love seat, something like that, another piece of furniture. Empty fish tank, and a bunch of stuff. Clothes, blankets, food products, right? No chemicals anywhere. So if we recall, Megan said that there was chemicals, and then she said there wasn't, and so on. There was food, but maybe there was chemicals. All right. But let's think about this logically, and the burns that he had on him. Let's first talk about this idea that this could have possibly been self-inflicted. There's nothing to suggest that Conrad was depressed or suicidal at all. So that's just pure speculation, number one. Two, I would speculate, since we're clearly speculating, that in the history of the human race, no one has killed themselves in this fashion. Right? This is not how someone does that. I can't think of a worse way to go. That's absurd. So let's put that out there. The second thing is the nature of the injuries and how they are distributed on him. Okay? They're from literally his head to his toes, the whole way. So let's remember, you had injuries on his feet, the whole way up his legs, on the back of his legs mostly, and a little bit on the front. Up on his arm, the back of his arm, on his fingers, and on his hands. And so to illustrate this, I am sorry, but I am going to show some of these pictures again. So, back side of the leg, front of the leg. Arm and elbow, the fingers and the hands, right? And it's mostly here on the thumb, okay? And then here on the fingertips. And then you have it here on the left shoulder, some on his left neck, then on his back. And look up here, where the burns are here, on his left shoulder, thick, still thick, and kind of trailing off. Now, and then up here on the top of his head. Now, let's remember what Dr. Varani said. Okay? He said that he was almost certainly, because of the pattern of burns, laying face down or partially on his right side. And that's exactly what's shown here. And it's the whole way along his body. And he was motionless. Right? We know this. He was passed out. He was motionless when this happened. And there's no space at either end of the couch for her to stand. If she's upset and just throwing powder willy-nilly, right, which would get the powder on her hands, as counsel was saying, maybe, might. How, if you're picking up and throwing stuff, is she throwing this straight onto the couch horizontal, straight on the couch, and getting that distribution of injuries? Right? She can't access either end to throw it possibly along his body and get there. That's not happening. She's throwing it straight on, except that's not possible. So let's talk also about some of these. You recall the spackling, right? Dr. Seawald mentioned how some of these injuries, there's thicker parts, they're deeper burns, and a little bit of speckling. This one in particular shows it. These injuries here that I'm looking at, the little smaller bits. That looks like something that would come from the dry powder, right? The powder from here. That could happen when you throw it this way. But these other injuries are much thicker, much deeper, much more consistent. This is not the same as these specklings. This is not just purely dry powder. This is powder that's gotten wet. And so I want you to look at this bottle and look at the powder that was still inside of it and how dry it is. And think about the powder that was on the back of the couch. And then I want you to look at this photo with the lye on the bottle. And I want you to look at the lye here on the couch. This is clumped, right? This isn't the loose powder that you're seeing here. That stuff's wet. Look at how clumped and thick it was. Look at the difference of the injuries and the spackling. If you had, it was all completely dry and she was just throwing it straight on angry willy-nilly like she says she was, like her claim that she accepts from the officers, right? You don't get this injury. You don't get the kind of thick burns, deep burns we have. If it was thicker and a paste, clumped up, maybe. Or if you mix it with water first. Because the water cools underneath the body when it's poured on him. Think about where the injuries are worst, when he's face down. She's laying face down, and she pours it on him, starting at the back of the legs. He's laying on the couch. You get the back of the leg that looks like that. You get some of those thick burns in the front, where he was face down, and the water cooled on the couch underneath him. You get instances where she's going up from bottom to front. You're going to get to the top, probably start running out, right?
And if he's laying on his right side, mostly face down, as Dr. Varani indicated, you're going to get that kind of drain trail over his shoulder. So you're hitting the left shoulder, and it goes down and comes underneath the shoulder where it would roll if it was already mixed in with liquid, if it was a solution. And there was liquid on the floor. There was a pool of liquid on the floor, according to both Lucas and the defendant's mother, and that couch is soaking wet. You can see it. Right, you can see the dampness there. And you can really see the dampness here in People's Exhibit 2. I wish this would stop doing this to me. Now, Julie Conrad would have you believe that this is a line from the couch being well sat in. Right? That's liquid. And then we think about the bottle cap. Where was the bottle cap? Look at all the other stuff around. There's no cleaning anything. It's just food. She didn't grab this out of some misguided piece of anger. She wasn't just grabbing things and randomly throwing things. First off, there's nothing else behind the couch. Surely if she's throwing all kinds of stuff in the bread, it would be shown, right? It would be here. We don't know where the lid is. I suggest that she got the bottle from somewhere else and the lid's there, right? That's why there's no lid around, is because she got the bottle, put water with it, and poured it on. Because it's the only way you get burns this thick. And it's the only way you can get the couch this wet and the water on the floor. Now, I want to talk a little bit about some of the witnesses they called. Listen. Conrad was drunk. There's no question about this, okay? He was. The idea, though, that if, he's telling you to extrapolate backwards in a certain amount of time when we don't have exact times because there wasn't enough people there. And he's asking you to take the exact word of the man who was apparently so drunk that if he had been at this point, he would have been literally dead, to have a perfect recall of exactly which moments and which times, and then he would probably be dead. Except there's no evidence on the record. And you have to only consider the evidence on the record as to the rate of absorption of alcohol for each individual person and what he would have been. Also, when he says it's a 0.3, what the hospital had was a 0.355 milligrams per deciliter, which we established was not the same measure as is used when we're talking about drunk driving. It's not the same measure. Is he drunk? Yes. No dispute. But to say that he surely would have been dead, so this is all wrong, is not the case. All right? The whole thing with the poop on the floor from Julie Conrad. First off, no one else said that. And there had been other people there. Kayla had been there. Austin had been there. Lucas had been there. Kevin Mason, the EMS, the paramedic of 15 years, and the fire chief had been there. No one else is talking about any poop on the floor. The person who did say that was the defendant's ex-wife and mother, the victim's ex-wife and the mother of the defendant charged with killing the victim. She said that while making jokes about, it looked like a tiger or there wasn't a tiger in the house, so it couldn't have been a cat. Because this is apparently something we joke about. Okay? I was stunned by that. I thought it was inappropriate. But this is not a person who is credible. All right? So I don't know why we'd be taking her word for anything. But I don't think there was anything on the ground like that. But there was the water. Okay? And so then we're back to what I thought was perhaps the most interesting thing that defense counsel said, which is for you to decide what you believe justice is. And that's the whole thing about this, and everything that they've said in the entire presentation they've made, is that Conrad was a drunk and the house was messy. And what do you think justice is in this situation? The only way I can interpret that question in this instance is that somehow this was justified.
right? They're trying to go back to 2007 for our victim's behavior and his health status. For the record, if he was on this stuff since 2007, he wasn't dead at 2021. I doubt it suddenly killed him in this moment in time on its own, right? But what is justified? Families are hard. They're complicated. Lots of bad things happen to a lot of families far too often, and it can be very difficult. And there's no question that this family was broken and is more broken now and will never recover. They're never going to be the same. But to suggest that because someone may have been a drunk or may have been a hoarder, that this might be justified is ridiculous. And it's offensive. There's no conception of this being justified, especially not in this country. And let's also remember that if this was such a bad situation for her to be in, that this could be justified, and what justice is wouldn't be a conviction here to what obviously happened and what had to happen, she could have gone to her mother's at any time. Right? She didn't have to stay there. She chose to live with Conrad in these conditions, in this supposed squalor that was so terrible and offensive to everyone. She chose to live there instead of living with Julie. And she could have left. What justice is, there is justice to be had in this case. And it is a conviction, as charged on count 1. Because that's what happened. And it broke the law. And we don't take the law into our own hands, and we don't decide justice based on the character of a person who was killed. This isn't about him. This is about what she did to him. She's guilty. That's justice. And I ask you to find it, so thank you.
Ladies and gentlemen of the jury, you have now heard the closing arguments, and this case is finished. I will now instruct you on the law. That is, that I will explain the law that applies to this case. Remember that you have taken an oath to return a true and just verdict based only on the evidence and my instructions on the law. You must not let sympathy, bias, or prejudice influence your decision. You must avoid reaching a conclusion that may have been unintentionally influenced by stereotypes. You must reach your own conclusions about this case individually, but you should do so after listening to and considering the opinions of the other jurors who may have different backgrounds and perspectives from yours. As jurors, you must decide what the facts of the case are. This is your job and no one else's. You must think about all the evidence and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each witness said. What you decide about any fact in this case is final. It is my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer says something different about the law, follow what I say. At various times, I've already given some instructions about the law. You must take all of my instructions together as the law that you are to follow. You should not pay attention to some instruction and ignore others. To sum it up, it is your job to decide what the facts of the case are and to apply the law as I give it to you. In that way, to decide the case. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This means this presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that she is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove her innocence or do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after careful and considered examination of the facts and circumstances of this case. Every defendant has an absolute right not to testify. When you decide the case, you must not consider the fact that she did not testify. It must not affect your verdict in any way. When you discuss a case and decide on your verdict, you may only consider the evidence that has been properly admitted in this case. Therefore, it is important to understand what is evidence and what is not evidence. Evidence includes only the sworn testimony of the witnesses, the exhibits admitted into evidence, and anything else that I told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. I will now describe some of the things that are not evidence. The fact that defendant is charged with a crime and is on trial is not evidence. Likewise, the fact that she is charged with more than one crime is not evidence. The lawyer's statements and arguments in any commentary, they are not evidence. They are only meant to help you understand the evidence and each side's legal theories. You should only accept things that the lawyers say that are supported by the evidence or by your own common sense and general knowledge. The lawyer's questions to the witnesses, your questions to the witnesses, and my questions to the witnesses are also not evidence. You should consider these questions only as they give meaning to the witnesses' answers. My comments, rulings, questions, summary of the evidence, and instruction are also not evidence. It is my duty to see that the trial is conducted according to the law and to tell you the law that applies to this case. However, when I make a comment or give an instruction, I am not trying to influence your vote or express an opinion about the case. If you believe that I have an opinion about how you should decide the case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide the case from the evidence. At times during the trial, I have excluded evidence that was offered or stricken testimony that was heard. Do not consider those things in deciding the case. Make your decision only on the evidence that I let in and nothing else. Your decision should be based on all the evidence, regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence, but you should not use any personal knowledge that you may have about a place, person, or event. To repeat once more, you must decide this case based only on the evidence admitted during this trial. As I said before, it is your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything that a witness said. You are free to believe all, none, or part of any witness's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice that you may have and not be influenced by a witness's disability, gender identity, race, religion, ethnicity, sexual orientation, age, national origin, or socioeconomic status. Again, take the time that you need to test what might be an automatic or instinctive judgments and reflect carefully about the evidence. There is no fixed set of rules for judging whether you believe a witness, but it may be helpful to think about these questions. Was a witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Did the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to make an honest effort to tell the truth, or did the witness seem to evade the question or argue to the lawyers? Does the witness's age and maturity affect how you judge his or her testimony? Does the witness have any bias, prejudice, or personal interest in how the case is decided? Have there been any promises, threats, or suggestions, or other influences that affect how the witness testified? In general, does a witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does a witness's testimony seem when you think about all the other evidence in the case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony that you accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It is also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that a witness deliberately lied about something that is important to how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things but told the truth about others, you may simply accept the part that you think is true and ignore the rest. The prosecutor must also prove beyond a reasonable doubt that the crime occurred on or about October 1st, 2021 within Oakland County. The prosecutor has introduced a statement that it claims the defendant made. before you may consider such an out-of-court statement against the defendant, you must first find that the defendant actually made the statement as given to you. If you find that the defendant did make the statement, you may give the statement whatever weight you think it deserves. In deciding this, you should think about how and when the statement was made, and about all the other evidence in the case. You may consider the statement in deciding the facts of this case and in deciding if you believe the defendant's testimony. Facts can be proved by direct evidence from a witness or an exhibit. Direct evidence is evidence about what we actually see or hear. For example, if you look outside and you see rain falling, that is direct evidence that it is raining. Facts can also be proved by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So, for example, if you see a person come in from outside wearing a raincoat, covered in small drops of water, that would be circumstantial evidence that it is raining. You may consider circumstantial evidence. Circumstantial evidence by itself or in combination of circumstantial evidence and direct evidence can be used to prove the elements of a crime. In other words, you should consider all the evidence you believe. You have heard evidence that before the trial, a witness made a statement that may be inconsistent with the statement here in court. You may consider the inconsistent statement made before the trial only to help you decide how you believe the witness's testimony when testifying here in court. If the earlier statement was made under oath, then you may also consider the earlier statement as evidence of truth of whatever the witness said in the earlier statement when determining the facts of this case. When the lawyers agree on a statement of facts, these are called stipulated facts. You may regard such stipulated facts as true, but you are not required to do so. You may consider whether the defendant had a reason to commit the alleged crime, but reason by itself is not enough to find a person guilty of a crime. The prosecutor does not have to prove that the defendant has a reason to commit the alleged crime. He only has to show that the defendant actually committed the crime and that she meant to do so. The defendant's intent may be proved by what she said, what she did, how she did it, or by any other facts or circumstances and evidence. You should not decide the case based on which side presented more witnesses. Instead, you should think about each witness and each piece of evidence and whether you believe them. Then you must decide whether the testimony and the evidence that you believe proves beyond a reasonable doubt that the defendant is guilty. You have heard that a lawyer talked to one of the witnesses. There is nothing wrong with this. A lawyer may talk to a witness to find out what the witness knows about a case and what the witness's testimony will be. You have heard testimony from a witness, Dr. Kenu Varani, who has given you his opinion in the expert field of forensic pathology. Experts are allowed to give opinions in court about matters that they are experts on. However, you do not have to believe the expert's opinion. Instead, you should decide whether you believe it and how important you think it is. When you decide whether you believe the expert's opinion, think carefully about the reasons and the facts that he gave for his opinion and whether those facts are true. You should also think about the expert's qualification and whether his opinion makes sense when you think about all the other evidence in the case. You have heard testimony from a witness who is a police officer. That testimony is to be judged by the same standards that you evaluate the testimony of any other witness. The defendant is charged with committing an unlawful act with a chemical irritant or device for an unlawful purpose resulting in death. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, the defendant placed, used, or released a substance. Second, that the substance that the defendant possessed, placed, used, or released was a chemical irritant. A chemical irritant means a solid, liquid, or gas that, through its chemical or physical properties alone or in combination with one or more other substances, can be used to produce an irritant effect in humans, animals, or plants. And third, the defendant possessed, placed, used, or released a chemical irritant to frighten, terrorize, intimidate, threaten, harass, injure, assault, batter, or kill Conrad Imirowicz. Fourth, that the possession, placement, use, or release of the chemical irritant resulted in the death of Conrad Imirowicz. You may also consider the alternative offense of domestic violence. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant assaulted and battered Conrad Imirowicz. A battery is a forceful, violent, or offensive touching of a person or something closely connected with her. The touching must have been intended by the defendant, that is not accidental, and it must have been against Conrad Imirowicz's will. An assault is an attempt to commit a battery or an act that would cause a reasonable person to fear or apprehend an immediate battery. The defendant must have intended either to commit a battery or to make Conrad Imirowicz reasonably fear an immediate battery. An assault cannot happen by accident. At the time of an assault, the defendant must have the ability to commit a battery or must have appeared to have the ability or must have thought that she had the ability. Second, that at the time Conrad Imirowicz was a resident or former resident of the same household as the defendant. When you go to the jury room, you will be provided with a written copy of the final jury instructions. You should first choose a foreperson. The foreperson should see to it that your discussions are carried out in a businesslike manner and that everyone has a fair chance to be heard. During your deliberations, please turn off your cell phones or other communication equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it is necessary that each of you agree on that verdict. In the jury room, you will discuss the case among yourselves, but ultimately each of you will have to make up your own mind. Any verdict must represent the individual considered judgment of each juror. It is your duty as jurors to talk to each other and to make every reasonable effort to reach an agreement. Express your opinions and the reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide you are wrong. Try your best to work out differences. However, although you should try to reach an agreement, none of you should give up your honest opinion about the case just because other jurors disagree with you or just for the sake of reaching a verdict. In the end, your vote must be your own and you must vote honestly. If you have any questions about the jury instructions before you begin deliberations or questions about instructions that arise during deliberations, you may submit them in a writing in a sealed envelope to the court clerk. The possible penalty should not influence your decision. If you find the defendant guilty, it is the duty of the judge to fix a penalty within the limits provided by law. If you want to communicate with me while you are in the jury room, please have your foreperson write a note and give it to the court clerk. It is not proper for you to talk directly with the judge, lawyers, court officers, or other people involved in this case. As you discuss a case, you must not let anyone, even me, know how your voting stands. Therefore, until you return with a unanimous verdict, do not reveal this to anyone outside the jury room. When you go to the jury room to deliberate, you may take your notes and the full instructions. If you want to look at any of the referenced documents or exhibits that have been admitted, just ask for them. When you go to the jury room, you will be given a copy of the written instructions that you have heard. As you discuss the case, you should think about all my instructions together as the law that you are to follow. The defendant is charged with one wrongful act in an alternative count that she is guilty of chemical irritants, unlawful use, or domestic assault, but not both. You should consider these alternates separately in light of all the evidence. You may find the defendant not guilty of chemical irritants, unlawful use, or guilty of domestic assault. I have prepared a verdict form of the possible verdicts. You will get one copy of the verdict form, but each of you will have a copy of the jury instructions. We will now dismiss 2 jurors who will not participate in the deliberations. Juror in seat 1.
Bingo night at the courtroom.
And juror in seat 6. You will not participate in the deliberations. I will be speaking with you in the hallway once everyone else has returned to the jury room. You may both go to the jury room and collect your personal items that you have left in there, okay? Okay, thank you. Anything with regard to the instructions?
Not in regards to the instructions, Judge. I was just going to ask for the alternate jurors who are being dismissed, they should be reminded not to watch any of the coverage in the event they are needed to come back.
Thank you. Yes. Both of the jurors who are not going to be deliberating at this time, you are still considered alternate jurors. Your service may be needed in the future, so you are not to have any discussion still with regard to this case until the matter has fully concluded. Okay? Anything further and with regard to the jury instructions?
I'm satisfied, Judge.
I'm satisfied as well.
Okay. All rise for the jury.
Well, it's the jury's case now, and to me, the demonstration of emotion here is the potential consequences are finally being recognized here. That they can't arrest me for this shit, or how can they arrest me for this shit? Question has been answered for her, and she sees how they can do it, and now suddenly the situation is far worse than I think she imagined it. Yeah, I'm kind of out of it now, of course, but I still use 24-hour time whenever I can. But time zone is just where I am.
Okay.
All right, Judge.
Thank you. I will let you know if there are any notes or anything from the jurors with regard to the exhibits. You should have those prepared and ready to go. Is it a flash drive?
For the videos and such, Judge, I have the pictures for the other things.
Okay. Make sure that we can play the flash drive, please. Okay. Thank you, everyone.
Well, I put the notes earlier. I had to leave at 11:30, so they have accommodated that, and so I'll go do what I got to do. And if the jury eats lunch, then I'll be back for the verdict and to try and pop it up if I see it. And certainly we'll chat about it anyway over the other stream if this one doesn't make it. Thanks everybody for coming in, and I will talk to you guys when we find out what happens in this thing.